Thank you for joining us. Today we'll be talking about an exciting and highly relevant topic, constitutional challenges to the FTC's authority. My name is Mary Gardner. I'm a partner in the Advertising and Marketing Practice Group at Venable. I represent parties in FTC investigations and enforcement actions, and I also counsel clients on advertising compliance issues that the FTC is closely monitoring. I'm joined by my colleagues, Clark Rinehart and Michael Munoz. Liz is a counsel who focuses on consumer protection, class action defense, and enforcement actions. Her practice spans the entire litigation lifecycle, from pre-litigation dispute resolution and compliance counseling to appellate practice. Mike is an associate in our advertising and marketing law group. Mike's practice focuses on FTC and other regulatory investigations and enforcement actions. Mike, could you advance to the next slide? Today, we're going to dive into analyzing challenges to the FTC's enforcement action authority. We're going to start with some necessary background on the historical basic background on the FTC's enforcement authority and the evolution of that over time. Then we're going to talk about a case that's currently before the Supreme Court that may have significant impact on independent agencies, including the FTC, going forward. And we'll finish up by discussing challenges that parties subject to FTC investigations and enforcement actions should consider when settling on their defense strategy. I'm going to turn it over to Liz to set the stage for our discussion today. And I will say we'd love this to be a dynamic conversation with you all. Please feel free to submit questions to the Q&A, and we'll do our best to answer them in real time. To the extent we're not able to get to your question during the webinar, we'd be happy to follow up with you by email afterwards. So Liz, I'll turn it to you.
Great, thanks, Mary. So I'm going to take us back to high school civics just for a little review of the three main ways in which our Constitution separates power for our government. So I don't know, those of you like me who love Schoolhouse Rock, there was the three-ring circus. So let's talk about the rings. The first is the legislative power. That's Article 1. All legislative powers herein granted shall be vested in a Congress of the United States. So that one's pretty easy to identify. We're talking about Congress. Article 2, the executive power. He shall take care that the laws be faithfully executed and shall commission all the officers of the United States. We're typically talking about the President of the United States there. And then Article 3, the judicial powers. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and to all controversies to which the United States shall be a party. That's another one that I think would be pretty hard not to identify with. It's the courts. The problem is when we start talking about independent agencies like the FTC, where do we put them? And so in order to figure that out, we're going to talk about the history of the FTC and how it was originally created and then how it evolved. So the FTC was established in 1914. Its original mandate was to prevent unfair methods of competition. Its original authority was to conduct investigations and report to Congress. So that seems a little legislative. And then to hear administrative proceedings and issue cease and desist orders, that feels a little like a judiciary action. It could also serve as a master in chancery. And I'm going to admit that I did a deep dive on this to figure out what it meant. And what it basically means is that in actions pending before court, if the court thought that some sort of remedy was necessary, it could refer the case to the FTC with an understanding that the FTC, they were masters of anti-competitive conduct and combating monopolistic conduct, and they could use that expertise to advise the court and suggest resolutions. I'll be honest, I don't see that in a lot of the case law, but I just had to share it. Another thing I want to point out is that originally, and to this day, the commissioner appointment is a presidential appointment with Senate oversight for 7 years. And the commissioners can only be removed for cause. Cause meaning, because this is going to be very important, inefficiency, neglect of duty, or malfeasance in office. I don't like reading to you guys, but that's very important, so I wanted to make sure I got it right. So next, I'm going to move over to Mike.
Thanks, Liz, and I appreciate the background and the Schoolhouse Rock reference. I'm going to take a couple more minutes to discuss perhaps the seminal case regarding agencies' independence, and that's the Supreme Court's decision in Humphrey's Executor versus the United States, which held that the removal restrictions, the FTC commissioner's removal restrictions, did not violate Article 2's Take Care Clause, which Liz referenced earlier. But first, how did we get there? For a little background, in 1925, President Coolidge appointed Humphrey to be an FTC commissioner, and then in 1931, President Hoover reappointed Humphrey, both presidents being Republicans. And that's important because in 1933, FDR was elected, and with him comes the New Deal. So Roosevelt asks Humphrey to resign multiple times, and Humphrey declined. And then FDR ultimately fired Humphrey for political reasons because he wanted to appoint somebody of his liking. However, Humphrey continued to work at the FTC even after he was fired, and then sued the president for his unpaid salary while he was still sitting in office after FDR fired him. And then when Humphrey died a year later in 1934, his estate continued to pursue the case. So now, as Liz mentioned, the president can only remove an FTC commissioner for inefficiency, neglect, or malfeasance. And Roosevelt's decision to fire Humphrey was based solely on political differences and not job performance. So the question for the court to decide is whether the president had the power to fire Humphrey such that he wasn't owed back pay. And what the Supreme Court says is no, the president doesn't have this power to fire Humphrey without cause. In doing so, the court has to determine what power does the FTC actually exercise. If the FTC exercises executive power, the president has that constitutional duty to take care that the laws are faithfully executed, and he can control officers, executive officers. So the court looks at the structure of the FTC, and in its view, the FTC was created to be a body of experts that either one, exercises quasi-legislative authority, as Liz referenced, it investigates competition and reports to Congress, or two, exercises quasi-judicial authority, where it adjudicates claims of unfair competition at the time and issues rulings or cease and desist orders regarding unfair competition. And so since the FTC's authority is not executive, the FTC's commissioners cannot be fired at will, so says the court in Humphrey's Executor. Now, in the wake of Humphrey's Executor and the New Deal, a lot happens at the FTC that brings us to the agency we know today, which I will turn it over to Mary to talk to us a little more about.
That's right. As Liz previously explained, pre-Humphreys, the FTC really didn't have an enforcement arm. It was hearing administrative proceedings in which it could obtain a cease and desist order against a party. But a lot changed post-Humphreys, and everything that changed post-Humphreys is what's leading us to our current fight against the FTC regarding Article 2 that we're going to spend a big chunk of today talking about. So, in 1935, the FTC has these administrative proceedings, and it's getting increasingly frustrated with its inability to prevent ongoing alleged misconduct while an administrative proceeding that could take years is ongoing. So in 1938, Congress responded to the FTC's concerns by adding Section 13A to the FTC Act. And 13A gave the FTC for the first time the right to go to federal district court for the limited purpose of obtaining a preliminary injunction. So that in and of itself was a big deal. But 1938 was even a bigger year for the FTC because it was also the year that Congress expanded the FTC's authority to include its consumer protection mandate, which has become so important to our practice. Decades passed, And then in 1973, Congress enacted Section 13B of the FTC Act. And that gave the FTC a robust enforcement option. So instead of an administrative proceeding, the FTC could now file a suit directly in federal court and seek both a preliminary and a permanent injunction. That may be raising your spidey senses about what an executive exercising an executive power under Article 2 may be. Significantly, this path to federal court did not include monetary relief. So, when during the next year, the FTC obtained a restitution award under Section 13B, the Ninth Circuit struck it down. So the FTC went back to Congress and requested that Congress grant the FTC the right to obtain restitution in these 13B cases. Congress rebuffed that request, but in 1975, Congress enacted Section 19 of the FTC Act, and this gave the FTC yet another enforcement path. It could obtain consumer redress for, in part, Rule violations. So FTC rule violations like the telemarketing sales rule. In the almost 50 years since the FTC's expansion of its enforcement authority, it has wielded that authority aggressively. But recently, the FTC has seen its use and interpretation of its enforcement authority called into question and diminished. First, with the Supreme Court's decision in AMG, and now with numerous percolating constitutional challenges under, separation of powers and due process and the non-delegation clause. So Mike is now going, with all of that relevant background, Mike is now going to discuss a case that's currently pending at the Supreme Court that could have significant ramifications for future challenges to the FTC.
Thanks, Mary. So now fast forwarding from the 1930s through the 1970s to today, SEC versus Jarchese is a case that started as a securities fraud investigation, turned into administrative action before an ALJ, had been appealed all the way up to the Supreme Court, where oral argument will be heard later this month. And not only will the court's decision have a big impact on the SEC's authority, but also perhaps the FTC's authority. The lower decision at the Fifth Circuit has already had a profound impact on defenses raised in FTC cases. So I'm going to kind of give you a primer on what the Fifth Circuit held in Jarchese and what's pending before the Supreme Court. So as I mentioned, the SEC brought an ALJ action against talk show radio host George Jarchese and his hedge fund companies, which I'll collectively refer to as Jarchese. And the ALJ found Jarchese liable for securities fraud, and then the commission affirmed the ALJ's findings and also imposed civil penalties and disgorgement. Jarchese appealed to the Fifth Circuit, what I thought was interestingly, only on the constitutional objections that he raised at the administrative proceeding earlier. And after full briefing and oral argument, the Fifth Circuit held that the SEC administrative proceedings suffered 3 constitutional defects. The SEC appealed to the Supreme Court, and the Supreme Court decided that it would review all 3 issues. So allow me to give you a little bit of overview of these issues that I have up on the slides here. The first being this, that the Fifth Circuit found that the commission's imposition of civil penalties in an administrative action violated Jarchese's right to a Seventh Amendment right to a jury trial. The Seventh Amendment provides that a jury trial provides a jury trial right in suits at common law. And in coming to its conclusion, the Fifth Circuit looked at whether the SEC's securities fraud claim was enforcing a public right created by statute or whether it's a traditional legal claim for fraud. The court determined that it was the latter, since claims based in fraud are traditionally a common law claim, which carries the right to a jury trial. Now, we don't see this a lot in FTC cases because the FTC doesn't have the authority to impose civil penalties in administrative hearing, but this issue may arise in the FTC context when it's seeking civil penalties in federal court. The second issue in Jarchese is a non-delegation doctrine challenge, where the Fifth Circuit held that Congress improperly delegated its legislative authority to the SEC without providing an intelligible principle for the SEC to implement that authority. And specifically, the SEC has the discretion of which forum to bring its cases in, either in federal court or before an ALJ. And since this affects defendants' legal rights, such as whether the federal rules of evidence apply or standards of review, the court found this to be a legislative authority. And the SEC has the exclusive authority and absolute discretion of where to bring these cases, thus failing to apply, or Congress failing to apply an intelligible principle. And finally, the Fifth Circuit held in the Supreme Court rule review that the statutory removal restrictions for SEC ALJs violate Article 2 Take Care Clause. Though the president has a certain degree of control over executive officers, generally speaking, what the case law says is that either inferior officers can retain for-cause removal protections, or officers of an expert board can have for-cause protections. And what the Fifth Circuit says is you can't have both. In this case, ALJs are inferior officers, and they can only be removed by SEC commissioners if the Merit System Protection Board finds good cause. And then in turn, both the SEC commissioners and the Merit System Protection Board can only be removed for cause. And thus, ALJs, SEC ALJs, have two layers of protection, removal protection from the president. So with that stage set for this argument at the Supreme Court, I'm going to turn it over to Mary to take a look at how we're seeing some of these challenges in the FTC context.
Excuse me. So now we're going to transition to discussing how parties that are in the FTC's crosshairs are using or should use the arguments at issue in Jarchese against the FTC as part of their defense strategy. So we'll start with discussion of Article 2 removal complaints, and then we will transition into discussion of the non-delegation clause and some due process arguments as well. So Liz, can you get us started with some Article 2 discussion?
I sure can. So just to sort of refresh things that Mary and Mike have already talked about, the reason why Article 2 hadn't been a problem when the FTC was first brought into being was because it was not an executive function that it was partaking in. It was legislative, it was judicial. Nowadays, though, everything it's doing feels very much like an executive action. And so what we're seeing is a little bit of questioning, even from the courts, including Chief Justice Roberts. I'll quote from Cielo Law: "The court's conclusion in Humphrey's Executor that the FTC did not exercise executive power has not withstood the test of time," which to me seems like the understatement of the year. So parties, this has not gone unnoticed, and parties have begun challenging FTC enforcement actions based on an Article 2 framework. And so yet again, we're going to the Fifth Circuit. We'll start with Illumina versus FTC. This was a multi-week administrative trial after which there was a unanimous decision that the acquisition in question violated Section 7 of the Clayton Act. It was appealed to the Fifth Circuit, and oral argument took place in September 12th, 2023. And there are many constitutional arguments, but we're going to specifically talk right now about the for-cause removal protections. So as we forecasted, the modern function of the FTC is primarily that of an enforcement agency bringing suits for injunctive and monetary relief. And this type of executive power is vested solely with the president. So we're waiting to see what the Fifth Circuit will do on that. Similarly, in FTC versus traffic jam events, the traffic jam events appealed the FTC's cease and desist order for violations of the FTC Act and the Truth in Lending Act. Again, we've had oral argument, so I keep wanting to say TGE. Traffic jam events argued both that the FTC commissioners and the ALJ's for cause removal provisions violated Article 2. As Mike had mentioned, the ALJs here are also doubly protected from removal. This is a really good case to keep an eye on because the Fifth Circuit was primarily concerned with waiver, and we're going to talk about waiver of constitutional arguments later. Here, the defendants raised the constitutional arguments in their answers and defenses, but they have not made them in the summary disposition briefing. So we'll see if that's the way the Fifth Circuit goes with that. Oh, sorry. And then finally, in talking about Article 2 challenges, I would be remiss if I didn't mention FTC versus Intuit. This was also an administrative action, and where the ALJ found for the FTC and denied Intuit's constitutional challenges. Now, again, there were a number of constitutional challenges here, but for our purposes right now, Intuit, relying on Jerkesi, argued that both the FTC commissioners and the ALJs were impermissibly insulated from presidential removal. The ALJ rejected this as foreclosed by Humphrey's executor, basically adopting that rationale and kind of dismissing the idea that the function of the FTC has changed to the point that Humphrey's executor is no longer appropriate. Intuit appealed. It's before the FTC commissioners, and oral argument is scheduled for November. So this is one we're definitely going to be keeping an eye on. And before I go on, for those of you getting CLE credits, the code is Enforcement 2023. Again, that code is Enforcement 2023. And with that, I'm going to pass it over to Mary.
So one effective defense the FTC has been able to raise to these Article 2 removal arguments is severability. So what's severability? It's essentially when one portion of a statute is deemed unconstitutional, a court will then need to determine whether that portion can be severed / removed while the rest of the statute remains in effect. So we've seen this come to pass in a few recent FTC cases. So for example, when Kachava, a company under investigation by the FTC for its data privacy practices, learned that the FTC intended to file a lawsuit against it, Kachava went on the offensive. They filed a lawsuit against the FTC, a declaratory judgment action, alleging in part that the FTC's structure, including its for-cause removal, violated Article 2 by providing improper insulation of commissioners from the chief executive, the president. 17 days later, the FTC filed that threatened complaint. Both cases moved in tandem for a period of time. The courts ultimately dismissed both Kachava's complaint and the FTC's complaint. Now, Kachava, importantly, had raised its constitutional challenges in both its complaint and in its motion to dismiss the FTC's complaint. So, in the order dismissing the FTC's complaint, the court commented on Kachava's affirmative defense regarding Article 2 removal and refused to grant dismissal on that basis. Essentially, the court held that, one, there was no violation of separation of powers, relying on Humphreys, saying that Humphreys still carried the day on the FTC's purpose and where it fell in the three buckets. And two, even if there were a violation of separation of powers, the FTC Act contains a severability provision. So the allegedly unconstitutional for-cause removal provision could be severed without impacting the FTC's ability to bring an enforcement action against Kachava. Now, it is important to note, just 3 days ago, the FTC filed an amended complaint against Kachava, so that case is going to be continuing, although likely without the Article 2 removal challenge. Similarly, in FTC v. Roomster relied on a similar argument in its motion to dismiss the FTC's complaint regarding Article 2 separation of powers violations. And the Southern District of New York also rejected the argument and relied in part on the same severability provision in the FTC Act. Now, can you forward to the next slide, Mike? Thank you. So that leaves us in a position of watching the court kind of say, so what, on these Article 2 arguments. There are, however, compelling arguments to fight back at a court's severability reaction to these Article 2 challenges. So, for example, in FTC v. Syngenta, one of the defendants, Corteva, argued that the FTC's enforcement action against Syngenta and Corteva should be dismissed due not only to the unconstitutionality of the for-cause removal provision, but went a step further and argued that the removal provision was not unconstitutional on its face. Instead, it was rendered unconstitutional by that later addition of the FTC's enforcement authority in the 1970s. So that goes back to our early history lesson. And the reason that is significant is that, Corteva's relying on case law that says when not one, but two portions of a statute are unconstitutional, you can't rely on a severability provision. I'm going to be really interested to see how this argument plays out. Oral argument is scheduled for December 1st, and I think that's a very compelling argument. You're seeing something similar in U.S. v. Stratix, and you may be wondering why U.S. instead of FTC. It's because the FTC referred a TSR complaint to the Department of Justice to obtain civil penalties. So the U.S., the Department of Justice is proceeding on behalf of the FTC. And in that case, Stratix has similarly argued that it is the FTC's enforcement authority that is constitutionally invalid, because that enforcement authority is the exercise of executive power, and that was not an issue in Humphreys, and so it requires, a renewed lens. Again, the court's ruling on that motion to dismiss is still pending. And again, we'll be watching these cases closely. And now Mike is going to talk about some other potential constitutional challenges to consider raising against the FTC.
Thanks, Mary. So moving on from the Article 2 challenge or challenges, the next challenge, which is also an issue that's raised in Jarchese, is this non-delegation challenge. And as a brief primer, the non-delegation doctrine is rooted in separation of powers principles. The theory here is, as Liz gave us the walkthrough earlier, all legislative powers are vested in Congress, and so Congress can't abdicate or delegate that power without a guiding or intelligible principle for an agency to exercise that power. So in Jarchese and the FTC cases we're seeing, the improper delegation of power or delegation of authority is in Congress allowing the agency to choose which venue has jurisdiction over its claims. Similar to the SEC, the FTC has the discretion to choose whether to bring its Section 5 unfair or deceptive acts or practices claims in either an administrative proceeding or in federal court. And we're seeing this argument play out in a couple of cases now. As Liz referenced this case earlier in Illumina, they also raised this argument, primarily relying on Jarchese. But this is a great example of the FTC exercising forum selection as a legislative authority, where it brought a merger challenge against Illumina in an administrative proceeding. However, it could have also sought a permanent injunction in federal court under Section 13B. And so here, the authority truly overlaps, and there's really no defining feature of how the FTC can exercise this discretion of where it wants to bring suit. Another case that Liz also mentioned in FTC versus Intuit, they raise this non-delegation challenge as well. And there, the FTC actually brought both an administrative challenge and a federal action for a preliminary injunction until resolution of the administrative challenge. Section 13B allows the FTC to obtain permanent injunctive relief in federal court. But again, here, the FTC made the strategic and discretionary decision to pursue a cease and desist order in an administrative proceeding. And what I find really fascinating about the Intuit case is the comparative reasoning in the ALJ's decision, where in the Article 2 challenge, the ALJ found that that challenge was foreclosed by Humphrey's executor, which we know rests on this idea of quasi-judicial, quasi-legislative authority that the FTC exercises, and therefore commissioners can't be removed by the president or ALJs. But then a couple pages later, the ALJ in Intuit rejects its non-delegation argument because it's a classic exercise of prosecutorial discretion. And I want to read that quote here because I just find it really interesting. In making choices about whether and how to enforce the laws it is charged by Congress with enforcing, the Commission does not exercise legislative power. Instead, it exercises enforcement discretion, a traditional executive power. So that's just fascinating, and oral argument is coming up later this month, so I'd be interested in seeing how that plays out. And another issue that I see here that we have yet to see what the answer would be is what is the remedy if a court finds that this choice in bringing an administrative action or bringing a federal action violates the non-delegation doctrine. The Supreme Court hasn't struck down legislation on the intelligible principle standard since Schechter-Poultry in 1935. So we have almost 100 years of not striking down a statute, and it might be quite difficult for a court to do so. So it'd be interesting to see what they do. And lastly, on the topic of non-delegation challenges, I just want to note that there are a few other FTC cases that are pending that raise non-delegation challenges, but with a unique rationale. In Kochava, which Mary mentioned earlier, they argued that the FTC lacks an intelligible principle of what is unfair or deceptive under Section 5. In Stratix, the defendants argue that Congress passed the Telemarketing Act without an intelligible principle. And in another case, FTC versus Precision Patient Outcomes, which is pending in the Northern District of California, they raise affirmative defense that the FTC, FDA, and DOJ have non-transparent overlapping enforcement authority over dietary supplements, and arguing that lacks an intelligible principle. So those cases are just something to keep an eye out for in looking at the different ways that non-delegation challenges are being brought. And so with that, I will turn to our last area of constitutional challenges, due process. And this argument really centers on the idea of being denied a fair trial in a fair tribunal. This is primarily raised in administrative actions before an ALJ. when the FTC proceeds administratively, it has a far and away a better batting average than proceeding in federal court. And so there may be some traction to this argument that the FTC can't be both prosecutor and judge where the commissioners issue CIDs, vote out complaints to be filed, actively choose whether to proceed in-house before an ALJ. And if they do proceed before an ALJ, they have de novo appellate review of an ALJ's decision. Again, Illumina raises this argument before the Fifth Circuit, where the ALJ actually rejected the commission's merger challenge, but then the commission reviewing the AL decision overturned the ALJ's ruling. Another case shedding light on the due process challenge, but is no longer pending, is the Axon versus FTC case. There, Axon brought a collateral challenge in federal court to the FTC's administrative proceedings. And after the district court dismissed Axon's collateral challenge, reasoning that it must exhaust those challenges before the administrative proceeding, the Supreme Court ruled that actually a district court can hear these collateral challenges outside of the administrative proceeding. So once Axon went back down to the district court, the FTC actually dismissed its merger challenge, citing costly litigation as the reason for dismissing the case. And of course, it's interesting that Axon contended that the FTC's intent was to actually moot the constitutional challenge and avoid an adverse ruling, and not necessarily just the years of additional litigation. And with that sums up the constitutional challenges that we've looked at here. But I want to turn to Mary to talk about some challenges to the FTC's statutory authority under Section 19.
Thanks, Mike. So if you've attended our webinars in the past or follow our blog, then you may already be well versed on the ongoing and successful efforts to rein in the FTC's power to obtain monetary relief, or in the case of the newer Section 19 claims, to make sure that we're making the FTC satisfy its burden of proof. So we're going to transition to talking about that. Mike, if you could go to thank you. So after obtaining the authority to go to federal court under Section 13B in the early 1970s, the FTC aggressively expanded its Section 13B authority to include the implied right to seek large monetary judgments from defendants. Section 13B quickly became the FTC's favored enforcement tool, again, reaping millions, if not billion-dollar judgments against parties. And that stopped in 2021 when the Supreme Court ruled in AMG v. FTC that Section 13B, under its plain language, only authorized the FTC to obtain injunctive relief, so preliminary and permanent injunctions, and not the monetary relief they had become so accustomed to obtaining. So the FTC has had to pivot. And part of that pivot has been an increased focus on Section 19 authority to attain monetary judgments. And it's more, and that judgment can include consumer redress and forms of damages. So if you're under investigation or you're a defendant in an FTC lawsuit and there are rule violations like the TSR or ROSCA, it's more important than ever to pay close attention to the FTC's evidence of and its calculation of consumer redress and damages. Mike, can you give us a brief overview on Section 19 to kind of inform the case law discussion we'll go to next?
Yeah, of course. Thanks, Mary. So Section 19, as Mary mentioned, had not been thoroughly looked at by courts, or at least not as much as Section 13B prior to AMG. So in the last 2 years or so, courts have had to increasingly look at the statute and try to understand what types of remedies they can craft in FTC cases that's permissible under the statute. So I figured we would look at the statute as well. The first part here says that the FTC can commence a civil action against any person that violates any rule. And that's part A of Section 19. Okay, easy enough. And then you move to Part B, which the statute defines what the FTC can obtain for rule violations. And what the statute says there is that Section 19 is specifically limited to relief that is necessary to redress injury to consumers. Now, this is far more narrow than what at least courts had considered equitable relief under Section 13B. And the statute here even lists out the types of relief that the court can provide. Rescission or reformation of contracts, the refund of money, return of property, or the payment of damages. So until AMG, the courts hadn't really had the opportunity to dissect how Section 19 limits the relief they can grant. And Liz is going to start us off on how courts have started looking at how they calculate consumer redress.
Thanks, Mike. And as Mike mentioned, what's happened is that courts have become increasingly interested in not only how the FTC is calculating its damages, but also how it's proving those calculations and whether the methods by which the FTC are supporting its damages theory are in accord with the actual statutory text. So we're going to move first to the Seventh Circuit. I know everybody's disappointed to be leaving the Fifth Circuit, but we have FTC versus Credit Bureau Center. And here, just to give a little bit of background, the allegations were related to a credit monitoring service that had a negative option feature. And those of you that have been following our blog, as Mary mentioned, I'm sure understand the negative option have been under increased scrutiny by the FTC. There were additionally allegations of fake rental properties. Basically, they directed applicants to apply for a free credit score, and then that resulted in the applicant being enrolled in the negative option program. So it was found that this violated ROSCA as well as the FTCA. And the FTC, having proven these violations, sought restitution under 13B of the FTCA. So the Seventh Circuit, ahead of its time, found that restitution wasn't available under 13B. And so the FTC petitioned the Supreme Court for a writ of certiorari. Originally, this case had actually been combined with AMG, but the Supreme Court split them up again, ruled on AMG, and then sent this back to the Seventh Circuit. The Seventh Circuit had stayed the case, issued its mandate, and sent this case back to the district court. From there, the FTC moved to amend under Federal Rule of Civil Procedure 59E, claiming that there had been a change in the law, and then basically asked for the same award to be granted under ROSCA, under a theory that they could obtain the exact same award under Section 19. And that would have been the award that's listed there. However, the Seventh Circuit upheld that judgment and basically held that Section 19 explicitly permits refunds to make the customers whole. So that would be the total revenues minus the refunds and chargebacks. However, the Credit Bureau Center had argued that the net profits must be traced to the underlying fraud, and the Seventh Circuit rejected that argument. The only thing that the Seventh Circuit did strike is the language that allowed the FTC to deposit excess funds with the U.S. Treasury, because that would be beyond the scope of consumer redress. So another case that we've looked at that relates to how courts are applying Section 19 is FTC versus Nolan. This case has a bit of a complicated history, and I'm not going to go all the way through it. But basically, Mr. Nolan had originally settled with the FTC way back in 2002. The FTC had accused Mr. Nolan of operating pyramid schemes. And then later, in 2023, the FTC brought additional claims that Mr. Nolan and some co-defendants were operating a variety of pyramid schemes. The court did find that there were pyramid schemes involved. And then, the FTC sought damages under Section 19 for violations of both the merchandise rule and the cooling off rule. And as a very, very simple refresher, basically the merchandise rule finding that when the defendants claimed that they were going to ship the goods, they did not have a reasonable belief that those goods would ship in time. And the cooling off rule was based on the idea that when the defendants sold tickets to educational seminars, they did not inform the consumers that they could cancel those ticket sales. So originally, as to the violations of the merchandise rule, the FTC had wanted over $500,000. The court reduced that to closer to $7,000. So that's a huge change, and basically said that Section 19 is only for redressing actual injury. And if the shipments were ultimately made, then there was no consumer injury to be redressed. And so that $7,000 represented instances where the defendants have rejected refund requests from consumers. So I think that's a very important, and I just want to underscore it. It wasn't just that, for example, they had violated the merchandise rule by not having a reasonable expectation of shipping in time. Here, the court actually required damages, injury to the consumers. And then similarly, with the cooling off rule, the FTC had asked for over $200,000 in damages, which would have represented the total revenue from training event ticket sales. Here, the court said, nope, you get absolutely nothing, because the FTC had not put in any evidence of refund requests. So therefore, the court found that there was no injury. So here, as the title says, the court was requiring that the FTC must show the receipts, and that's a big change from past cases, and it's going to be interesting to see how the FTC responds to that.
Thanks, Liz. Yeah, and kind of following Nolan, Zappas, FTC versus Zappas in the Southern District of Texas is another case that follows Nolan's reasoning. There, the FTC sued Zappas for merchandise rule violations resulting from the belated shipping of personal protective equipment and purportedly refusing to offer refunds to consumers who didn't receive the PPE during the advertised shipping window. And at summary judgment, the FTC asked the court for the defendants' entire net revenue of PPE sales, which was north of $37 million. And the defendants responded that under Section 19, the FTC is required to show that each individual consumer, that relied on these statements in order to obtain consumer redress for those consumers. And what the court did was, in denying summary judgment, was it said it has to be something in the middle. According to the court, the FTC can show that there was some form of consumer injury by showing that misleading claims were widely disseminated, which tracks the case law that carried over from Section 13B. However, the next step that is required in Section 19 cases is that the FTC has to show and produce evidence for the amount that is necessary to redress consumers. And I emphasize necessary there because that's really what the case is trying to get to, is what amount is necessary to redress consumers. And so since the FTC didn't present evidence that every consumer that purchased PPEs would need a full refund, which was the refund or the amount of consumer redress it was asking for, the court denied summary judgment, and it appears that this case is going to go to trial in December to just on that sole issue of the amount of damages under Section 19. So I'm going to transition to our last case, and most recent case, which is FTC versus RCG Advances in the Southern District of New York. And this case, again, looks at the scope of Section 19 consumer redress. And in RCG Advances, the FTC sued a business and its owner under the Gramm-Leach-Bliley Act for misrepresenting terms of its cash advance agreements that it made with small businesses. And if you're not familiar, or if you're kind of popping your head up as what is Gramm-Leach-Bliley Act, it's a statute that the FTC is allowed to enforce that, in short, prohibits someone from obtaining another's financial information or a consumer's financial information through misrepresentations. And the GLB Act, or the FTC treats GLB Act violations as rule violations for the purpose of obtaining Section 19 relief. And so in that case, the FTC submitted an expert report saying that the damages amounted to about $4.8 million for overcharging and overbilling customers. And in reaching its conclusion, the expert report sampled 87 out of almost 1,500 transactions, then calculated the average overcharge or overbill and extrapolated that average back out into the entire 1,500 transactions. And the court first rejected this calculation because the pool contained transactions outside of the statute of limitations period, the 3-year period of transactions that were at issue. And the court also rejected this calculation because the expert report failed to explain how 87 transactions was an appropriate sample size for and could be extrapolated to a larger pool of transactions. In an effort to remedy this issue and kind of foreseeing the court's summary judgment denial, the FTC submitted a declaration from the expert in its summary judgment reply, stating that about 1,300 of the transactions fell within the statutory period. And so the court also rejected these representations and rejected relying on this report because they were only filed on summary judgment reply. And so the defendants didn't have an opportunity to dispute or test the veracity of the expert's report. So the important takeaway from RCG and the rest of these recent Section 19 cases, as I was mentioned when we started talking about Section 19, is that courts are really starting to hold the FTC's feet to the fire as to what's the scope of the damages, how damages are calculated, and are these damages necessary to redress injuries to consumers.
So that takes us to steal a phrase from Mike, how can parties who are in the FTC's crosshairs use these constitutional challenges and these damages challenges to hold the FTC's feet to the fire? First, and as Liz pointed out earlier, you need to avoid the risk of waiver. So assert these potential constitutional objections early and often. Raise them in your CID responses, in affirmative defenses to complaints in federal court, in pleadings and administrative actions. Just use them, raise them, fight for them. Similarly, if the FTC indicates it's going to bring an enforcement action, in the wake of the Supreme Court's decision in Axon, you should consider whether you should bring a pre-enforcement challenge to argue some of these cases if you are in a favorable jurisdiction with a court that may be inclined to reconsider the Humphreys line of precedent. You know, and then, you know, when we think about damages, you know, that goes to your strategy in discovery, at summary judgment, at trial. Make the FTC prove its damages, really calculate them. As you've seen in the cases that Liz and Mike just went into, when defendants make the FTC account for its damages, it frequently has trouble doing so because, you know, it never really had to do that in some of the Section 13B cases. Liz, Mike, do you have anything to add for practical takeaways?
Liz, I don't. I think you covered it well there, Mary.
You did, and I would just definitely underscore in terms of the evidentiary burden for damages. I see that as being like an area that is just ripe for defendants to find a way just to even like chip down at their damages. Like obviously, no one wants to be held liable, but if you are held liable, it's a method in order to make the amount that you may have to pay more manageable. And it's worth the investment during discovery, as Mary mentioned.
Absolutely. That's a great point. So for those of you still with us who may have missed the CLE code in the middle of the presentation, the CLE code for today's presentation is Enforcement 2023. Enforcement 2023. And you will receive a link to submit the CLE code via a form at the end of the presentation. We very much appreciate all of you being here today. Please don't hesitate to reach out to any of the three of us if you have any questions that you'd like to discuss with us offline. And again, thank you.